An Introduction to Constitutional Law, 100 plus Supreme Court Cases Everyone Should Know by Randy Barnett and Josh Blackman. Baker versus Carr, 1962. The Constitution recognizes that the states have the power to regulate, quote, the times, places, and manner of holding elections for senators and representatives. Likewise, the states also have the power to regulate local elections. This power includes the authority to draw legislative maps. Since the framing, state legislatures have drawn legislative maps to benefit the political party in power. In 1812, Governor Elbridge Gerry of Massachusetts approved a legislative map that was favorable to his Democratic-Republican Party. Gerry was pronounced with a hard G, like the name Gary. The misshapen and jagged districts on the map resembled a salamander. An outraged Federalist newspaper coined the term gerrymander. That Massachusetts map is now known as a political gerrymander. But there's another type of gerrymander. With a racial gerrymander, states draw legislative districts to dilute the political power of racial minorities, in particular black voters. For example, in 1957, the Alabama legislature redrew the boundaries around the city of Tuskegee. Previously, there was a square boundary around the city. But the legislature changed the municipal boundary to a, quote, strangely irregular 28-sided figure. And the new map removed virtually all black voters from the city, but removed no white voters. As a result, black citizens could no longer vote in Tuskegee elections. In Gomillion v. Lightfoot, 1960, the Supreme Court held that the Alabama map was unconstitutional. Specifically, this racial gerrymander violated the 15th Amendment, which provides that states cannot abridge the right to vote based on, quote, race, color, or previous condition of servitude. Yet, the Gomillion Court did not base its ruling on the 14th Amendment. 2 years later, in Baker v. Carr, 1962, the Supreme Court considered whether the federal courts could hear a challenge to legislative maps based on the Equal Protection Clause. Every 10 years, the federal government conducts a census to determine the population in each state. The Tennessee state constitution required that legislative districts must be redrawn after each census. Under state law, each district must include substantially equal population, that is, roughly the same number of people should be apportioned to each district. However, in the 6 decades following the 1901 census, Tennessee did not redraw its districts. During that time, Tennessee, quote, experienced substantial growth and redistribution of her population. For example, Shelby County, which contains the city of Memphis, had about 10 times as many residents as some of the rural districts. Yet, Shelby County's representation had not increased in 6 decades. Justice Clark observed in his concurring opinion that, quote, 37% of the voters of Tennessee elect 20 of the 33 senators, while 40% of the voters elect 63 of the 99 members of the House. Clark wrote that, quote, the apportionment picture in Tennessee was a topsy-turvical of gigantic proportions. Charles Baker, a resident of Shelby County, filed suit in federal court against Joe C. Carr, the Tennessee Secretary of State. Baker and other voters alleged that the state legislature, quote, arbitrarily and capriciously apportion representatives without reference to any logical or reasonable formula. In other words, the state representatives and senators were not fairly apportioned or distributed based on population. The plaintiffs charged that this malapportionment, quote, debased their votes, and thus violated the Equal Protection Clause of the 14th Amendment. The Supreme Court would not decide whether Tennessee in fact violated the 14th Amendment. Rather, the court only decided a threshold question. Could the federal courts hear a challenge based on the 14th Amendment to the state's legislative maps? The court answered this question yes, by a 6-2 vote. Justice Brennan wrote the majority opinion. Let's begin with a brief summary about the powers of federal courts. There are three important concepts: jurisdiction, standing, and justiciability. Jurisdiction. Was the constitutional issue raised by the case within the power of federal courts to decide? Yes. Article 3 of the Constitution defines the judicial power. And pursuant to Article 3, the federal courts have jurisdiction to hear, quote, all cases in law and equity arising under the Constitution. Baker's case, Justice Brennan wrote, arises under the 14th Amendment. Therefore, the federal courts had jurisdiction to hear the case. Standing. Were the plaintiffs the right persons to bring such a challenge? Yes. Baker was disadvantaged by Tennessee's distorted legislative map. This injury, the court held, grants Baker, quote, standing to maintain this suit. Justiciability. Is there something about this issue raised that makes it impractical or improper to be resolved by a court? No. But it is not enough for the court to have jurisdiction and for the plaintiffs to have standing. Rather, the dispute must also be justiciable. The concept of justiciability is hard to define. Indeed, the court spent many pages explaining the difference between a justiciable and non-justiciable case. We'll state the conclusion up front. The court held that Baker's challenge to an apportionment presents no non-justiciable political question. A political question is a dispute that ought to be decided by a politically accountable body like the legislature. The court ruled that Baker's challenge did not involve such a political question, and therefore the case was justiciable. Now we will explain these two interrelated issues, the political question doctrine and the doctrine of justiciability. In Marbury v. Madison, 1803, Chief Justice Marshall articulated an important limitation on the judicial power. He wrote that the federal courts could not decide certain questions that were entrusted to the political branches. This principle came to be known as the political question doctrine. The federal courts cannot resolve a political question. Such a dispute is non-justiciable. For example, certain disputes about foreign policy are committed to the discretion of the executive branch. Moreover, disputes based on the Constitution's guarantee clause are also political questions. The guarantee clause reads, "The United States shall guarantee to every state in this union a republican form of government." The Supreme Court has held that the judiciary cannot resolve what happens if a state fails to maintain a republican form of government. In such a conflict, the court has said that it lacks, quote, judicially manageable standards to make such, quote, policy determinations. Baker, however, did not bring suit under the Guarantee Clause. Rather, his claim was premised on the 14th Amendment. Justice Brennan identified 6 factors that affect whether a dispute is a political question. First, with a political question, there will likely be, quote, a textually demonstrable constitutional commitment of the issue to a coordinate political department. Second, with a political question, there will likely be, quote, a lack of judicially discoverable and manageable standards for resolving it. Third, it may be impossible to decide a political question, quote, without making an initial policy determination of a kind clearly for non-judicial discretion. Fourth, it may be impossible to, quote, undertake an independent resolution of a political question without expressing lack of the respect due coordinate branches of government. Fifth, a political question may involve, quote, an unusual need for unquestioning adherence to a political decision already made. And sixth, resolving a political question may lead to the, quote, potentiality of embarrassment from multifarious pronouncements by various departments of the government on one question. In light of these factors, the court held that a challenge to apportionment is not a political question. Specifically, with regard to the second factor, the, quote, judicial standards under the Equal Protection Clause are well developed and familiar. And the court has developed, quote, judicially manageable standards to determine that, quote, discrimination reflects no policy, but simply arbitrary and capricious action. For example, the court could review a racial gerrymander with strict scrutiny. In the end, the court held that Baker's, quote, allegations of a denial of equal protection present a justiciable constitutional cause of action. Baker versus Carr did not decide whether Tennessee violated the 14th Amendment. Indeed, the majority opinion avoided any mention of race. During oral argument, Justice Douglas asked Baker's attorney if this case was
based upon racial distinction.
The lawyer replied that in Gomillion versus Lightfoot, there was
discrimination based on race
in Tuskegee, Alabama. However, Baker versus Carr, the lawyer said, was
not a racial case.
Yet race was very much at issue with the Tennessee map, as well as with maps throughout the South. During the 20th century, many black families migrated from rural areas to urban cities. By 1950, malapportionment severely restricted the political power of black voters in cities like Memphis. In 1950, Professor V.O. Key of Harvard University wrote that, quote, by the overrepresentation of rural counties in state legislatures, the whites of the Black Belt gained an extremely disproportionate strength in state lawmaking. Even though Justice Brennan's majority opinion did not discuss race, the separate opinions in Baker addressed this issue indirectly. In his concurring opinion, Justice Clark suggested that racial animus motivated the state's policy. He wrote, quote, that Tennessee's apportionment is a crazy quilt without rational basis. In dissent, Justice Harlan responded to Justice Clark. In Harlan's view, Tennessee did not, quote, arrange its electoral districts with a deliberate purpose to dilute the voting strength of one race. Indeed, Harlan wrote, quote, nothing in the Equal Protection Clause supports the view that state legislatures must be so structured as to reflect with approximate equality the voice of every vote. Here, Justice Harlan cited Williamson versus Lee Optical, 1955. Harlan contended that the state's policy could have rested on some rational basis. Harlan made up rationales that could have supported the law. For example, the state could have found that the 1901 map, quote, constitutes a desirable balance of geographical and demographical representation. Or perhaps, quote, in the interest of stability of government, it would be best to defer for some further time the redistribution of seats in the state legislature. The Tennessee legislature did not actually rely on either rationale. However, under the Lee optical standard, the courts would not, quote, strike down state laws because they may be unwise, improvident, or out of harmony with a particular school of thought. Harlan concluded that, quote, so long as there exists a possible, rational legislative policy for retaining an existing apportionment, the policy does not violate the Equal Protection Clause. Study guide. In cases leading up to Griswold versus Connecticut in 1965, the Warren Court departed from the deferential Lee optical standard. The majority opinion in Baker versus Carr, 1962, which did not even cite Lee optical, further illustrates this trend. Justice Frankfurter also wrote a dissent. Like Harlan, he maintained that Tennessee's maps were not premised on race. Unlike the racial gerrymander in Gomillion versus Lightfoot, Frankfurter explained, Baker versus Carr was, quote, not a case in which a state has denied Negroes or Jews or redheaded persons a vote or given them only a third or a sixth of a vote. He also warned that the majority opinion would inject the judiciary into the political process. He explained that the court cannot neutrally resolve conflicts based on claims of debasement or dilution of votes. After all, there is no, quote, defined standard of reference as to what a vote should be worth. The 14th Amendment, Frankfurter wrote, does not require, quote, the representation ought to be proportionate to population. The majority opinion, Frankfurter explained, found a political conception of equality, quote, in the broad and unspecific guarantee of equal protection. This discovery, he charged, quote, is to rewrite the Constitution. But Frankfurter advocated for judicial restraint. In Frankfurter's view, under the Constitution, there is not, quote, a judicial remedy for every political mischief, for every undesirable exercise of legislative power. After Baker versus Carr, lower courts now had the authority to consider the constitutionality of legislative maps. And soon, judges began to block racial gerrymanders. 2 years later, the Supreme Court decided Reynolds versus Sims, 1964. This case held that seats in Alabama state legislature, quote, must be apportioned on a population basis. The state violates the Equal Protection Clause when a map dilutes a citizen's right to vote in a, quote, substantial fashion. Reynolds followed the principle of one person, one vote. And in 1965, Congress enacted the Voting Rights Act. We will consider this landmark statute with our discussion of Shaw versus Reno, 1993.